Here on Nicholas Corpus. All right. Hello.
Good morning, Your Honor.
Good morning. How are you doing?
I'm doing okay. How about you?
Oh, I'm doing all right. So we were here last time, and the reason why we were here is there was a request.
All right, folks, buckle up, because what you're about to see is far from routine. This case, State versus Nicholas Corpus, dives deep into the tug-of-war between rehabilitation and accountability. On one side, we have a defendant who's been on GPS monitoring for over a year with no violations. On the other, a complainant raising safety concerns, backed only by what the judge bluntly calls double, maybe triple hearsay. The stakes? Huge. We're talking the potential for 10 years behind bars if probation is revoked. But here's the twist. Has Nicholas proven he deserves freedom, or is this just the calm before another storm? Stick with us, because the judge's decision is going to surprise you.
For the GPS removal.
Yes, Your Honor.
And the court was inclined to do that, but then the court received different information from the state, and I believe the defense had not had an opportunity to review it. So you're here today requesting removal of the GPS, correct?
We are, Judge.
All right. Court is calling 2023 CR 7339, State versus Nicholas Corpus. Can I have parties announced?
Ashley Jones for the state.
Linda Corley for Mr. Corpus.
Off the record for a moment. So on Avila to the interpreter, as soon as this hearing is concluded, can you give me 5 minutes?
Yes.
All right, thank you. I'll call you up after this. We're back on the record.
Thank you, Judge. My client has been on GPS for an unusual length of time. Part of his probation was that you had ordered him to be on GPS for an indeterminate time. You wanted to see how he did on probation. He's been on for, I think, almost 14 months now.
Excuse me, just 1 second. Guys, we're on the record. Okay, you may continue.
He's been on for almost, I think it's around 14 months now, not counting the time that he was on pretrial.
Mm-hmm.
I was given at the last hearing, as you know, some information about alleged attempted contact by my client. This time we're denying all of that. That was back in April of 2024. There's been no warrant issued. I didn't have any information on
So
this.
the alleged contact is from April 2024?
Yes.
Is that correct, State?
Yes.
All right, and so has a case been indicted, a case been brought?
No, Your Honor, it is awaiting filing.
All right, you may proceed.
Judge, other than that, as you know, at the last hearing, probation actually told you that he's been a model probationer. He's not had any problems whatsoever. He's followed all the rules, and obviously it's very extensive. GPS is no small matter. Besides everything else, my client has not attempted to contact the complainant. He has absolutely no interest in that. And we would request that the GPS be removed at this time because he has followed all rules.
All right, State.
And if you'll recall from last time, Your Honor, we had reached out to the complainant to see if she had any safety concerns or how she felt about the GPS being removed. She expressed she did have safety concerns and did not want it removed. I informed the court of such. Additionally, I informed the court of the DPO from June of 2024, and that the victim had expressed to me a friend or a person she knows to be a friend of the defendant had viewed her LinkedIn profile, and so she just didn't know if people were.
So what we have is double hearsay.
Correct, Your Honor.
Maybe triple hearsay.
But on behalf of the complainant, the state did object to the removal of GPS.
All right. So again, the court sees, and of course, I don't make any decisions until cases are brought before me and motions are filed, but there is a legal issue having a case that's been in your office since 2024. And there has been no movement to seek an indictment. It's just out there in the ether. And then you want him to be in limbo on GPS. Probation has informed the court at the previous hearing that there have been no issues with him on GPS.
This is a fascinating courtroom moment. Notice how probation is essentially backing Nicholas, saying he's been a model probationer with 0 violations for over 14 months. That's rare. Judges themselves admit how difficult it is to stay on GPS without a single slip-up. Meanwhile, the state's case rests on indirect claims, friends of friends allegedly viewing LinkedIn profiles. That's not exactly the smoking gun you'd expect. The real issue here is balance. Should a defendant's proven record of compliance outweigh vague safety concerns? And here's the kicker. If Nicholas makes just one wrong move, deferred adjudication could instantly flip into a decade-long prison sentence. Viewers, what do you think? Should the judge weigh more on performance or on precaution?
Which, counsel, I will note, it's hard to be on GPS and not receive any type of violations. And probation has informed the court that he has not violated GPS. And I had him on specific GPS to begin with. He did well on that. And then the court moved it to tracking only. And then now we're here. And how long has he been on GPS?
Almost 14 months, Judge,
Yeah.
since he did his plea.
November 2023.
Yes, so he's been on GPS since November 2023, and he has had no violations. And probation, has he completed everything?
His bed, his top. He's done well with the spill visits. There are no outstanding cases, no outstanding conditions.
All right. I don't see any reason why GPS should not be removed. I mean, if there's a concern, if the state has a concern with the complainant, then, and I know it's not your fault, but if the state has a concern with the complainant, then this case should have been moved through whatever process it should have been moved through towards indictment. A grand jury will look at it. Either they will indict it or they won't indict it. But to have his life in limbo, to have the complainant's life in limbo, and wanting the court to continue to have everybody in limbo, the court is not going to do it. He's been on GPS since 2023. There's not been any violations, and I think both parties can agree with me. To be on GPS and have zero violations is next to impossible. In my time as a defense attorney, I'd only had 2 clients who have been able to do that. So here's the thing. You're on deferred adjudication.
Yes, Your Honor.
If a motion to revoke is filed, you're looking at potentially 10 years in the prison. You are not allowed to contact the complainant. The court doesn't have anything before it to suggest to the court that you contacted the complainant, other than some double hearsay, maybe triple or quadruple hearsay. I have nothing of that nature. But what I can tell you is, if there is credible information that you've contacted the complainant or had third parties to contact the complainant, in case you don't know it, that would be a violation. So if some third party, you have them to contact the complainant on your behalf, it's a violation of your probation. Do you understand?
I understand.
All right, relationship is over. You understand
I
that?
understand that.
All right, is there anything else?
There's
From the
nothing,
state?
Judge.
All right, GPS will be removed. Continue what you're doing, and you can come back later once the time is appropriate for early termination.
Thank you, Judge.
Thank you,
You're
Your
welcome.
Honor.
Thank
Thank you,
you.
Judge.
Nicholas Corpus. Wait a minute, who's the attorney?
I am.
Oh, come down then. Come down.
That says May.
Are you ready to proceed on the motion?
We are, Judge. We have agreed.
All right. Court is calling 2023 CR 7339 State versus Nicholas Isaiah Corpus. Can I have parties announced for the record?
Ashley Jones, from the state.
Linda Corley for Mr. Corpus.
And are you Mr. Corpus?
Yes, Your Honor.
All right. Did you review the motion to enter adjudication of guilt with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Nicholas Isaiah Corpus who was placed on deferred adjudication in 2023 CR 7339 for the offense of assault, family choking, strangulation on November 9th, 2023?
Yes, Your Honor, I know.
All right, state.
Your Honor, the state is going to proceed on violation of condition number 1 on or about the 27th day of April 2024 in Fairfield, Texas. The defendant, Nicholas Isaiah Corpus, committed the offense of violation of bond and violation of condition number 1.
How do you plead to that? True or not true?
True.
And the state will waive the remaining violation.
Any objection?
No objections.
Did you understand by pleading true to violation of condition number 1, the court could find it true, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
I did understand, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
True.
No, do you still want to proceed with that?
Yes.
All right, the court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor. First amendment is to deny the motion to enter adjudication of guilt, continue the defendant on probation, put him on 6 months of GPS traffic only with the waiving of the fees. Additionally, to add a condition that there would be no application for early termination for at least 2 years.
All right, so here's my question. He's on deferred adjudication for assault, family choking, strangulation. He's just pled true to a violation of bond conditions, and I'm making an assumption, if I'm incorrect, let me know, that this violation bond or protective order is against the complainant.
Yes, Your Honor.
So why would he be continued?
Judge, this offense happened a year ago, and he hasn't had any other violations. It was actually not filed, but we had come forward for a compliance hearing to remove the GPS, which was granted. And at that time, that's when we were informed about this case. We didn't know anything about it until then. And so they didn't. So then the state went ahead and filed the case at that point. So it was a year ago. We haven't had any violations since then. I believe that probation, I don't know if they'll want to come speak, had recommended continuing as well. He hasn't had any other violations, Judge. And this was not a threatening situation or anything like that. It was very short phone call. And
What was the phone call for?
it was he just called her by her nickname and said, "I love you," and then hung up.
I don't want anything to do with you anymore. So did you make this phone call? Did you make this phone call?
Yes, Your Honor, I did. I was not in my right place of mind.
How do you feel about it now?
I do deeply regret it. And I have been reformed, and I'm a productive member of society ever since I've been out of Bear County Jail and since I left Lifetime Recovery.
All right.
And Judge, there haven't been any other.
So this incident from a year ago, I don't understand if this happened a year ago, why are we here? And it's really beyond a year. So why are we just having this addressed now?
Judge, probation sent in a request for early termination, and when, as a court, one of the stipulations, you have the state contact the victim to see if they're objecting to it, and when the state objected to it based on the victim's statement, is how this all came about.
And I can speak to that, Your Honor. It seems that the violation of protective order was filed at large, so probation wouldn't have any idea about it until it was filed with that office. When we called to speak with the complainant at the last early termination hearing, she informed us that she didn't understand why this violation of the protective order wasn't going forward or had to be filed. So that's when we looked into it. That's when I said the violation of the order forward. That's why we're here today.
And if I can clarify, Judge, the case wasn't actually filed, and it was until the day after of our compliance hearing. Then they went and filed it. So we didn't know anything about it, and there wasn't a warrant issued yet, I don't believe.
So what's happening with this new case?
Since we couldn't really put it on this agreement, but the agreement is to plead until the case as well. Probation for that as well.
To run concurrent with this case on the deferred.
All right. I still don't understand why.
And Judge, just to be clear also, I had filed a motion for early termination as well, but we didn't proceed with it because the new case was filed.
All right, this is what I still don't understand. I still don't understand why there's a case that's out in the universe for over a year. I don't understand that. I'm telling you what I'm going to do. Since y'all are pleading him to that violation of protective order, and when is that going to be done?
I'm going to be representing him pro bono on that. I don't have his court date, but he's bought it out and he does have a court date. So we're planning to go in and do that.
And that's which court is that in?
I believe it was in 7. Is that right?
I do believe it's in 7, Your Honor.
All right, court is going to deny the motion. And the court is terminating him unsatisfactorily.
So, here's the final takeaway. Despite showing progress, Nicholas Corpus's probation ends with an unsatisfactory termination. Why? Because even one phone call, a violation of bond conditions, was enough to tip the scales. The judge makes it clear, probation is not babysitting, and safety concerns carry real weight. This case highlights the razor-thin line defendants walk under deferred adjudication. One wrong step and years of hard work can collapse instantly. Now over to you, was the judge too harsh, or was this the only way to protect the complainant? If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Is there anything else? All right. Thank you.
Well, thank you, Judge.